this court's rulings regarding this case is giving you bad advice, it's going to likely end up in you being incarcerated in jail. I don't want to put you in jail. I want you to comply with the court's orders. But I'm not going to tolerate you playing games. And I don't think the bankruptcy court's going to do that either. And so you might get prepared, because I think the bankruptcy court, when Ms. Patton hires a lawyer and they proceed in the bankruptcy court, they're going to take a dim view of you attempting to use that process. Anyway, that's the order of the court. You may step aside. You may.
So, Your Honor, I had two other things that I'd like to discuss, if possibly.
What are those?
So I would like to be on the record. I'd like to preserve that the deed was recorded before the written order was entered under Tennessee Rule of Procedure 58. A judgment is effective only when written and entered. And third, the deed acknowledgement is defective because I was never personally before a notary. And then, like I said, I asked that the property issues be continued. As far as the check, I have no knowledge of where that check is or where it's supposed to be. Ms. Duke told the court that it was at her office, and I agreed to go sign that check at the office. She later told me that it had been mailed to somebody or somewhere, and at that point in time, I have no knowledge or receipt of this check, Your Honor. So it's not a matter of trying to get around not signing it or avoiding it or anything like that. I have no knowledge of where this check is, and I've not been requested by Ms. Duke to come to her office and sign for this check.
Judge, we have confirmation and tracking that it was dropped off at Mr. Patton's home, and I can't control where the insurance company sends a check. I represented to the court that as they had told us, they were going to send it to my office. They did not. We've got tracking to show that it was sent to his house. He knows he has it, and he's refusing.
Once again, Your Honor, I do not have the check, never received it. If it was mailed to the house, it's not at the house, so.
Ms. Duke, this court will order the insurance company to issue that check in your client's name only and to issue it directly to your office. And by order of this court, I'm directing the insurance company to issue the check solely to Mrs. Patton, and because she is the true owner of the property, and it's to be issued and mailed to your office, sua sponte. Secondly, your request regarding, or your objection regarding the deed execution is overruled and denied.
Understood, Your Honor.
And I will point out, the original order trumps everything.
This court ordered it from the bench, and it's just like any other order in this court. If it's not in, even though it may not have been a written order at that point, you were ordered to do certain things and you did them. So it doesn't matter if you signed a deed because I ordered you to do so, then later saying, well, that order hadn't been, the written order hadn't been entered, is an attempt to, again, subvert and get around what this court says. Why would you object to the order being, why do you even object? Tell me why that is.
Because I've filed a motion 60.02 to contest this whole process, Your Honor. So it's been under contest since I filed my motion 60.02. And then Your Honor ordered me to sign a quitclaim deed over on the 10th, or excuse me, the 15th.
I'm overruling your objection to the deed because of the fact that this court is of the opinion that you did so in compliance with the court's order. Your Rule 60 motion will have to be heard after the bankruptcy court deals with you.
Well, and it was in compliance with the final decree, so it even goes back that far.
There is nothing in the decree that states that I am to sign a quitclaim deed, Your Honor, and give up my rights to a $150,000 debt. It's attached to a $150,000 debt.
We'll deal you first, and then we're going to go back to the Thomas case.
Thank you, Judge.
We'll stand in short recess.
Almost 2 years later, we're now about 3 years out from where the order was filed. And all these items that are listed in the order for her to return, some of the stuff Mr. Claiborne has been reunited with. There's really nothing in the record to suggest that Ms. Childers still has these items. There's nothing to suggest that she has this $42,000. I understand this is civil contempt, but she has to have the ability to purge herself of this, and there's nothing to show that 3 years later that she currently has the ability to purge herself of this contempt. So basically what we're looking at now is basically a debtor's prison. She doesn't have the ability to purge herself, which there's nothing to show that 3 years later she now does. it's become punitive. And because of that, Your Honor, I would ask that the court alter its order or just enter a new order to release her, to show that she's, she's been in jail, 4 months now? The appropriate remedy for Ms. Childress would be to release her from custody. So I'd ask that you grant our motion, modify her sentence to 10 days, and to release her time served from the Dixon County Jail.
Ali, you wish to make an opening statement?
So I remember that we did have some court dates kind of after that October date, Judge. I have put together, and I've given a copy of it to Mr. Guerin. This really is nothing.
You may be correct. This has been, that order was from a hearing in 2024, and as a result, I'm not sure that my memory of it would be as clear.
I've shared this with Mr. Guerin. We talked yesterday, and then I gave him a full copy of my timeline today that's got everything attached to it. I tried to streamline this because this file is rather voluminous and different orders and things flying around. But this is all the orders, the motions, the things that I felt like were important to and germane to our issues here today. If you look at the timeline, there was a February 15th, 2024 court hearing, and what all led up to that a little bit. And then there's also a June the 4th hearing on the motion to approve the order. And we did have those other two court dates. I had lodged an order with the court. And again, the court had some issues with the order, wanted some amendments. And we had that February 15th hearing, which I sent notice to Ms. Childress at the two physical addresses and her email that I had. And we had that hearing, and the court instructed me on what to do on the 15th of February. And then there was another change on the 4th of June at our hearing there. And then I submitted an order that the court signed on June the 18th. So this court took special care with this order. The first order I sent in, I did it like I do the civil contempts and whatnot, jailed indefinitely. And the court said, no, you didn't want that. You wanted a provision in there for her to have 6 months of incarceration and to be let out after that. So she was not jailed indefinitely. And there's some other things in there too that this court did that, again, taking careful consideration with the order that you did. Our position today, Judge, is really one of a few things. One, I've filed a response in opposition. If we're going to oppose this, obviously, I think the court, and I can get into the argument on that if the court wants, but I think the court took great care with this order. I don't think there's anything that's inappropriate with this order. If the court will remember, it was a fairly egregious situation where she had gotten a domestic assault on Mr. Claiborne, got control of the house, and basically ransacked the house. There were, and the court heard hours of testimony about defecation in drawers of Mr. Claiborne's clothes, urination on the furniture and the beds and things of that nature. There was a lot going on at that time. And Judge, basically, we are asking that, number one, if we're going to go forward with the motion to alter or amend, that be denied. I think the court did what the court was supposed to do with that. Number two, let her out of jail with some stipulations. We're fine with that. You know, she's here today basically wanting to get out of jail. That's what this motion is about. What we're about today, Mr. Claiborne just wants what's due him, what his justice is out of this order that the court did. Either his stuff back or the money paid, and we've already beat that horse all the way around the track, and there's an order down for that. But we say she's got some time left on her 6 months. Let's stay that, or however the court wants to do it. This is contempt, and the court has the absolute reins, in your hand to do what you want to do here. You're driving this bus. Let her out of jail. Let's reset this maybe to the 1st of December. Give her a little bit of time to either make some payments, get this stuff back. Let her know that this is a serious matter. I don't know if she understood it was this serious, but let her know it is a serious matter. And let's come back in December and see what she's done and it's up to the court then to do what the court wants to do, to see what her conduct was during this period of time. We're not getting any satisfaction here seeing her in jail. You know, Mr. Claiborne wants the return of the property or his money back. And at that time, there was a present sensibility for her to be able to return this property. The court found that. It's in my response. And I'll be glad to go over the response and argue this in detail if we need to. But at this time, we're fine with letting her out. But put a few stipulations on it that we've got a reset date. I may want to file some interrogatories about her. We think maybe she's gotten a settlement, some things like that. We want some sworn answers about that, and either continue this motion to alter, amend until then, or do whatever the court wants to do. But we're fine with that as well. That's, I think, probably the preferred remedy for Mr. Claiborne, to be honest with you. So one of those two is what we're requesting. And again, I'm a little in the dark here as to what we're doing. If we're arguing only the legalities of this, I'd like some more time. If you know, we're calling witnesses, obviously that's up to Mr. Garrett, it's his motion. But if we're calling witnesses, you know, I may call some witnesses, especially Mr. Claiborne, to contradict some of the things. But by and large, if we're going to argue this legally, I'd like to have an opportunity basically to argue it legally. But those are, as far as my opening statement goes, that's what it is. Thank you,
Well,
Judge.
this court considers this situation to be similar, if not exactly. I am ruling that we're going to let Ms. Claiborne, I'm going to discharge her from jail today, and subject to a review, and there will be an order. It'll take a little bit for them to get a typewritten order, but she's going to be discharged on the civil contempt and be brought back in January for me to review what she's done. So I just want to let you all know, so that even if she needs to get out of there, then y'all can let her out by my order to you today, because even if the written order takes a little bit.
Yes, sir.
All right,
Got it.
thank you. Y'all are free to go, by the way.
I own that residence.
Okay, and can you describe for the court the residence? How many bedrooms, bathrooms?
Sure, yes, sir. It's 17-acre farm with,
Pull that microphone up there to you. Ms. Thomas is on Zoom, and so it's important that she be able to hear everything.
that has been set up specifically for Scarlett. And you know, I've not been given the name of baby Thomas. We're referencing her. You know, so this room was set up for these girls, and this is bedroom number 1.
Okay, and do you have clothes? Does it depict in those pictures clothing for the minor children?
Yes, sir. There is some clothing there. There are toys there for the girls, and yes, sir.
Okay, so if the court were to return the children to you, you've got everything set up that you need to take care of the children, is that correct?
Yes, sir. That's
Okay.
correct.
And Judge, I'd move to make that. Did you take those pictures?
I did, yes,
And
sir.
is the condition of the residence in the same condition as it was in those pictures that you took?
The exact precise position that these pictures show, yes, sir.
Judge, I'd move to make those
All right,
collective
if you'll
exhibits.
pass that to the clerk so that she can mark it as an exhibit, please.
No objection for the record.
Guess I should have asked you first. So.
And Mr. Thomas, just to get through some more background information before we kind of get into everything, where are you currently employed?
Currently, I'm employed at Clarksville Granite Company.
Okay, are you the owner of Clarksville Granite Company?
I am the owner, yes, sir.
Okay, and that is an S corporation, is that correct?
It is, yes,
Okay.
sir.
But you are also employed by them, but you are the business owner.
I'm going, for the record, I'm going to show these photographs to Ms. Thomas so that she's able to see what's been marked as Exhibit 1 since she's appearing by Zoom.
Sir.
Sorry. All right, thank you. You may proceed.
And Mr. Thomas, how long have you owned Clarksville Granite Company?
October 1st, 2018. That would put us at 6, 8 years, a little over 8 years now.
Okay, and what do you typically do? What does a day-to-day look like there?
Day-to-day for me looks like I handle pretty much everything at that business. These days I wear most every hat there. We sell granite countertops. We install granite countertops. We manufacture and fabricate granite countertops.
And do you have employees there that work for you?
I did have many employees when I was married. Well, I'm still married, but when Rachel and I were together, I had about 5 to 6 employees and 3 subcontract installers. Yes, sir.
Okay. And so do those employees no longer work for you?
They no longer work for me.
Can you tell the court what happened?
Sure. So after the protection order was put into place, I had never suspected. I was caught off guard, so I went back and I started looking in all of my media devices that I owned to find out why my wife was making these false allegations against me. And as I looked through all of these devices, I found messages from many different men. I found pictures in my game cameras all over my farm where men were coming into my house. They were driving into my home. So that's what I found and some of those men worked for me, and many of my employee base, pretty much my entire employee base, was having some type of relations with my wife. And so when I found that out, I lost all of my employees. 2 of those were my sons.
And so you've had a significant reduction in your workforce there at Clarksville Granite, is that correct?
Yes, sir, I did.
Even though that significant reduction has occurred, do you still maintain flexibility with your work schedule?
Yes, sir. So that we've been able to keep the doors open. I did lose my entire cabinetry division as a result of my wife's actions. So that entire crew I had to let go because of what was going on there. I have one gentleman that works for me now, and he is my subcontract installer, and he also helps me fabricate granite countertops.
So if the court were to return eventually the kids to you, would you be able to facilitate childcare while you're at work? Would you be able to facilitate daycare and things of that nature?
Yes, sir, I have made those arrangements.
And are there specific individuals in mind? Is there
There-
someone here today that would be willing to help you with the children?
Yes, sir, there are people here today.
And so kind of getting into a little bit of the backstory, when did you and Rachel marry?
We got married on April the 13th of 2024.
Okay. And what led to the separation?
The separation, I had no idea we were separating. What led to it, it came out of nowhere to me, to be honest. It was one day we were married, and the next day she was gone and making false allegations about me. I was totally blindsided by this.
Okay. And was there a specific point in time when that happened? Did she go out of town for a period of time?
Yes, sir.
Okay. And what happened when she came back?
Sure. So first, Rachel asked me to buy her a ring to recommemorate our marriage. This was 7 days, no, maybe 2 weeks before she made false allegations against me. She asked me to give her $7,000, 5 or 7, to buy a wedding band that she wanted to recommemorate our wedding. And I gladly gave it to her. I was in love with her, you know. I gave her the money, and supposedly she bought the wedding band, and she said she wanted to go to my sister's wedding for a period of about a week, and also some type of girls thing they were doing for about a week, and she left her children, her 13-year-old and 15-year-old teenage child with me, while she went to Atlanta, Georgia, spent 1 week, and during that week, we had some telephone disagreements, and she had mentioned that she was pregnant at the time, and that she wanted to have put the baby up for adoption. And part of the argument that we had while she was there was that I did not agree to the adoption. I in fact expressed to her that I would prefer to divorce her than than to adopt our child out. She did not want the child. She felt like her hands were full and she did not want to take the responsibility of that baby. And so I several times on the phone, I probably have messages, I conveyed to her that I would prefer to divorce her than have an abortion. So the night that she returned from this Atlanta trip is the night that she hit the record button on her phone, sat down, started an argument with me. The next day I woke up and the cops were there telling me I had to leave my home and that she had made false allegations against me.
And so can you explain to the court what your relationship was? How old is Scarlett, first of all?
Right now, Scarlett's 14, 15 months old.
Okay.
And,
And how long has it been since you've seen Scarlett?
I've not seen Scarlett for last September.
This past September?
Yes,
okay.
sir.
And what was your relationship like with Scarlett prior to Miss Thomas leaving?
It was a beautiful relationship that she had become my whole drive in life. I was presented with this little angel every morning when I woke up. I would spend about an hour and a half with her before I went to work while Rachel prepared for her days. I would take the baby and take care of her during that time before I left for work. When I got home from work, Scarlett was given to me because Rachel had had a long day, taking care of her. By the time I had gotten home from work, every day without hesitation, she was thrust upon me, take the baby, and I would rush home from work to take that baby. I was in love with that baby. I still am, but I've had to push it all in the back and not think about it because it hurts so much so that was our relationship. Like I took total care of the baby while I was at the house.
Did you provide for her? Did you provide food, clothing?
Yes, sir.
Medical care? Did you ever take her to the doctor?
As far as the doctor, I think we did go to a doctor visit one time, yes, sir.
And she had a primary care physician when she was here?
She did. We had set her up with one of my pastor friends who is a physician's assistant and has a practice in Clarksville. His name is Cliff Signer.
And so you had mentioned a moment ago about the adoption and being made aware of the adoption. Did you take Miss Thomas seriously when she had mentioned sending this newborn child or setting this newborn child up for adoption?
I didn't really think it was that serious, no, especially when I told her that I would divorce you. That was my way of saying we're not doing this.
Did you ever tell her if she signed divorce paperwork, you would sign adoption paperwork?
I may have said those words in a message to say to her, if this happens, we're getting divorced. The only way this is happening is if we get divorced.
Did she ever consult any adoption agencies that you're aware of?
So I'm not aware that she consulted any
Were you ever
adoption
a party to
agencies.
any of those conversations? Did you ever consult with any adoption agencies?
Absolutely not.
Okay.
This whole adoption was, I did see in an email where she was reaching out in social groups on Facebook where she was soliciting Facebook groups to find a person to adopt this child. And I think I sent you those emails where she had, this was after the divorce was filed. We were no contact. But
So after that order of protection had been entered, after the divorce had been filed, you had no contact with her about the adoption?
That's correct, sir.
Okay. She didn't tell you she was about to place the child up for adoption? She didn't tell you that she was signing a termination of her parental rights?
I had no idea any of those things were happening. I was in the dark as to.
And you only
any
found out that it
information.
occurred after you'd been served with that
Yes,
petition,
sir.
is that correct?
I had suspected, that she was considering that, but I had no idea.
And so it's been represented to the court that you have been convicted of domestic assault. Now, let's go back. You had described earlier an incident in September. Is that the incident you're referring to?
Yes, sir.
Okay. And what plea did you enter? Do you
Well,
recall?
I don't recall the name of the plea, but I do recall that the attorney advised me that after the judge read the plea off and I agreed to it, that to be sure that I say not guilty within that I'm not guilty of this. I don't remember the name of it, but it was when the judge said, "How do you plea?" It was very clear that my attorney made it to me to say the word, "You plead not guilty."
If the court records reflect you entered into a no contest plea to a simple assault and a violation of an order of protection, does that sound accurate?
Yes, sir.
Okay. And you were, as a result of that, you were placed on probation for a year, is that correct?
Yes, sir.
And are you currently still on probation?
Yes, sir.
Have you had any issues with probation?
No, sir. I
Have you
have
failed
not.
to report to probation?
No, sir. I
Have you had
not.
any probation violations filed against?
And so extrapolating that out, what is your salary per year?
Here, let me give him back his income and expense statement then, if he's going to be questioned.
Yeah.
Did you say that there was a copy of that in the file?
There's
Here, let me take this apart again. All right, go ahead, I'm sorry.
And so if you get paid $800, is it fair enough to say that you're paying yourself through the business approximately $41,000 to $42,000 a year?
Yes, sir. That's correct.
Okay. And this is a business you own, right?
It is.
Sole proprietorship?
No, it's an S corp.
S Corp?
Yes, sir.
Are you set up as the sole managing member of the S Corp?
Yes, sir. I am.
Okay, so in terms of who gets to pay who, you get to make that decision top to bottom, right?
Yes,
You don't run anything else past anyone else as far as your income is concerned, correct?
that's correct.
Okay, and I see on your income and expense statement that it says your business pays telephone, car payment, and car insurance. Is that right?
That's correct.
Okay, so you use, like most people do that have a corporation or any sort of business, you use your business profits to be able to pay some of the things for your personal life that you get to use on a daily basis too, right?
Absolutely not.
No?
No.
Who pays for your car?
So my car, so my personal life, I have a motorcycle that I drive. I have other vehicles. This particular car that you're talking about is my work vehicles.
Okay, so do you owe anything on any of your other vehicles?
So I owe money on the vehicle that Rachel drives.
Okay, what about any of the other vehicles that you had? You said you had multiple vehicles in your possession.
That's right. That's what I owe. My motorcycle is paid off and I owe what Rachel is driving.
What other vehicles do you have?
I have a 25 Mustang.
And you bought that right after y'all separated, right?
That's correct.
And you actually paid cash for that?
I did.
Okay, so
No, stop. I did not pay cash for that. That's finance. I'm sorry.
that's finance,
It
but
is
it's paid off
financed.
at this point, right?
No, it's not paid off.
You got money owed on that?
Yes, I do.
Who's paying for that? Your business, right?
I pay for that.
You pay for that
Yes,
through your business?
that's right.
Okay, so that's what I'm getting to, right?
Okay.
You pay for your stuff through your business, right?
This is a work vehicle.
It's your 2025 Mustang for a granite company is a work vehicle.
Absolutely.
You can haul granite on your 2025
I
Mustang?
drive that car to every measurement job, to every meeting, to work and back every day. This
Understood.
car does not sit in my driveway and I don't take it to car meets. I drive it to work. I drive it all around to measure jobs every day.
Understood. And so as far as that car is concerned, you're actually adding on to that vehicle as well, right? You've bought a bunch of parts for it to add on to it, make it faster, make it more cool, right?
No,
No?
I've not. Let me see. I did put a new muffler on it. Yes, you're right.
Did the business pay for that too?
It did.
Was that necessary for your business, or that's just something you want to put on the
It's
vehicle?
regardless. That's not a question, whether it's necessary for business or not. Whenever I purchase a saw for my granite company, I'm allowed to purchase blades for that saw that increase its productivity.
Understood. Let's talk about your business account then. How
Sure.
much do you have in your business account?
Currently around $100,000.
Okay, so you get to pay through your business account anything that you deem necessary for your life that you think benefits your business, right?
If it's business related, yes,
And you say that you had $100,000 in there right now, right?
that's correct.
Okay. Previously, you had a lot more than that, right?
That's correct.
Okay. I'm gonna pass up a document to you.
Sure.
You recognize this statement, right?
Yeah, the one that was stolen from my vehicle when she stole my truck, yes.
Get to that in a minute, I guess, then. When it comes to this